So now let's get to what we all been waiting for, a presentation on reasonable accommodations and modifications in housing. And just a real quick note, we had one very small change to the presentation. So if you had downloaded a copy earlier this morning or yesterday, please go to our website for the most updated presentation. And again, I'll put that link in the chat box. So it is my pleasure to be able to introduce our presenters today, Evie Yost and Luciene Parsley. They're both attorneys at Disability Rights Maryland. So at this time, I am going to pass the mic over to them and let them introduce themselves and get us started with our presentation. So go ahead.
Great. Thanks so much, Emily. I'm Luciene Parsley. I'm litigation director at Disability Rights Maryland. I'm an attorney there, and I work on our systemic litigation. But I like to say I started off as a fair housing attorney, so at the end of the day, I always consider myself to be a housing attorney. So I'm always very excited to do these presentations. I've worked for Disability Rights Maryland for over 20 years. I started actually in law school and worked on a fellowship after I graduated on fair housing issues, and have stayed at Disability Rights Maryland. So I'm going to turn it over to Evie to introduce themselves.
Good afternoon, and thank you, Emily. My name is Evie Yost. I'm a staff attorney on the housing team at Disability Rights Maryland, where I work on some of the systemic litigation related to housing. And the majority of my work is doing direct services around fair housing. So using reasonable accommodations and modifications, like we'll be discussing today, to help folks with disabilities remain securely and stably housed. And I also joined Disability Rights Maryland initially as a housing fellow 3 years ago. So this is my third year at DRAM.
Great, thank you. Could we go to slide 11, please? Thank you. So I wanted to explain a little bit about who Disability Rights Maryland is, and a little bit about the P&A system as a whole. So my organization, Disability Rights Maryland, is the federally designated protection and advocacy organization for the state of Maryland. Every state has a protection and advocacy organization, and we're the one for Maryland. Our mission is to advance the civil and legal rights of people with disabilities. We enforce fair housing rights. We help prevent evictions and voucher terminations. We protect against abuse, neglect, rights violations in state hospitals, state residential centers, residential treatment centers for youth. We also work in the community, and we protect the rights of people living in nursing homes, prisons. DDA is our Developmental Disabilities Administration. They're funded residential services. We also protect the rights of people living in residential rehab services or group homes, and many more. Some of our areas of work include special education, transportation, voting advocacy, and Medicaid. Could we go to the slide 12, please? Okay. So together, all the protection and advocacy agencies comprise the nation's largest provider of legally based advocacy services for people with disabilities, and those services are provided to people free of charge. So P&As have the legal authority through our federal statute to investigate suspected abuse or neglect and seek justice for victims and their families. Through our statute, we have access to records and facilities necessary to investigate abuse and neglect and to monitor the treatment and safety of residents. We are directed by our federal legislation to pursue litigation and all other appropriate remedies under federal, state, and local law. We provide information and referrals regarding entitlements to services and other legal rights. We educate policymakers on needed reforms to disability-related laws and services, and we do things like this training, presentations, and outreach. So I encourage you to get to know your P&A. Can we go to the next slide 13, please? So this is the contact information for the protection and advocacy agencies that are in the mid-Atlantic area. Not all of them do exactly the same work. For example, ours in Maryland, I think, is larger than some of the P&As. I'm sure with the exception of Pennsylvania and Virginia. But we, for example, do housing advocacy, and not all P&As do. But all P&As exist to protect the civil rights of people with disabilities. Could we go to the next slide, please? 14. So I wanted to talk a little bit about why we wanted to do this training and why this is important information for people to know. For example, knowing your fair housing rights helps you to be part of your community, to enforce your rights, to take control of your housing and your integration into the world. Fair housing complaints concerning reasonable accommodations and disability access comprise over half of all fair housing complaints that HUD receives. And it's been like that since the very beginning. I often, when I do these presentations, I talk about how one of my first internships when I was in college, I worked for a short period of time for the NAACP Legal Defense Fund, and that was in 1988, believe it or not, but the Fair Housing, or 1989, I think, and the Fair Housing Act had just been passed. And one of the things they asked me to do was to go and pull all the fair housing complaints through a FOIA that had been filed with HUD to try to see how many of them had to do with race. And from the very beginning, everyone was kind of shocked that the vast majority of fair housing complaints had to do with disabilities. So those numbers have always stayed very high. Those complaints that involve requests for reasonable accommodations and assistance animals are significantly increasing. Most HUD charges of discrimination against a housing provider following a full investigation involve denial of reasonable accommodations to a person who has a physical or a mental disability, often an invisible disability that the housing provider cannot readily see. So that information, I got the 2023 information from the National Fair Housing Alliance, but I think through 2021, HUD published that data every year on the number of complaints that they received every year. Okay, so could we go to slide 15, please? All right, so just to give a roadmap for what we're going to do today, we are going to talk first. Evie's going to give an overview of federal and state housing laws that protect the rights of people with disabilities. We are going to talk about Maryland, but we want you to understand that your state law may be a source of very important rights for you, especially in the current political and legal environment. We're going to then talk about understanding reasonable accommodations and reasonable modifications and what the difference is. We're going to think through reasonable accommodations and modifications, meaning when you might ask for them, when they apply, how to use the law to get what you need in your life. And we're going to talk about common barriers. So if you're assisting someone that may have fair housing issues, what are some common barriers to consider, and how would you address them when requesting a reasonable accommodation? And finally, we're going to apply the skills you've learned today to some common scenarios. Okay, and I'm going to turn it over to Evie for slide 16. Thank you.
Okay, so now we'll discuss some sources of law protecting the civil rights of people with disabilities in housing specifically. Can we move on to slide 17? Great. So the three major fair housing laws, the federal laws we'll be discussing today that protect the rights of people with disabilities as it relates to housing are the Federal Fair Housing Act, as amended, Section 504 of the Rehabilitation Act of 1973, which covers housing specifically that receives federal funding, so federally subsidized housing, and the Americans with Disabilities Act, specifically Titles 2 and 3. Title 2 covers housing funded by state or local government, whereas Title 3 covers places of public accommodations, such as the leasing office of an apartment complex. And we'll talk more about that in a moment. Can we move on to slide 18? Thank you. So the Federal Fair Housing Act is probably the fair housing law that I personally work with the most in my practice as a housing attorney. The Fair Housing Act was enacted initially as Title 8 of the Civil Rights Act of 1968, and then was later amended in 1988 to prohibit disability discrimination in housing to overcome historic segregation. And the Fair Housing Act applies to most housing, both private and subsidized housing. That includes all different types and formats of housing, like condos or HOAs. And the Fair Housing Act specifically prohibits landlords, property managers, leasing agents, etc., from discriminating in the sale, rental, or terms and conditions of housing on the basis of someone's disability, as well as discrimination in the application and screening phase when someone's trying to become a tenant, during the tenancy, and during the termination of a tenancy. So if it comes to eviction proceedings, the Fair Housing Act still applies to discrimination in those processes as well. So for people with disabilities, the Fair Housing Act also requires specific affirmative actions to be provided to give them an opportunity to be accommodated and reach a minimum level of accessibility in their housing. Can we move on to slide 19? Great. So more examples of what is considered unlawful under the Fair Housing Act. It is unlawful for a landlord, a leasing agent, a property manager, someone selling their home, to take these actions on the basis of a person's disability. So refusing to sell or rent, making housing unavailable, which includes advertising housing as available only to people without disabilities. For example, language in a listing for a unit that mentions independent living requirements, that is considered illegal under the Fair Housing Act. It's unlawful to discriminate in the terms, conditions, privileges in the sale or rental, such as requiring a co-signer or case manager to sign for someone with a particular type of disability, refusing to make reasonable accommodations, which have been specifically requested by the tenant or prospective tenant, and as well refusing to permit reasonable accommodations to be made to a unit at the tenant's expense when that is the tenant's obligation. And we'll talk more in the next portion of the PowerPoint about who is required to pay for reasonable modifications, because often it is the tenant, but not always. And then threatening to coerce or retaliate against anyone for exercising their fair housing rights under the Fair Housing Act is also illegal. Okay, next slide, slide 20. There are a few exemptions to the Fair Housing Act. So these are situations where those unlawful behaviors we just described would not apply to specific types of housing. So number one is single family housing that's sold or rented without the use of a real estate broker. To some extent, that also applies, right, to single family housing that's sold or rented without using specific apartment listing websites. Can kind of depend on the factual situation. But the second exemption would be housing operated by organizations and private clubs that limit occupancy solely to their members. Third would be housing that is legitimately restricted to seniors, either 62 or older or 55 and older, as opposed to housing providers that inappropriately restrict their building to seniors or the elderly, when the perhaps subsidy, the funding source does not require that. And then the fourth exemption, which we colloquially refer to as the Mrs. Murphy exemption, is owner-occupied buildings with 4 or fewer units in them. Okay.
Hey, Evie, can I ask you a question?
Yes.
Because this came up in the chat.
Oh, great.
Homeowners associations, are they subject to the Fair Housing Act?
Yes, we talked about that, I think 2 slides back. But they should be, as long as they don't fall within one of these FHA exemptions, then yes, a homeowners association would be covered by the Fair Housing Act.
I'll just jump in and say this is like one of my favorite topics because HOAs, I can't tell you how many of their lawyers have told me they're not subject to the Fair Housing Act, and they absolutely are. All right, Evie, I'm letting you go back in.
Thanks, Lou. I'm having trouble keeping up with the chat. So yeah, just let me know if there are more questions. Let's move on to slide 21. So what kinds of units are covered? Well, we know HOAs generally are. Multifamily complexes with 4 or more units would be covered under the Fair Housing Act's accessibility requirements. So long as the landlord doesn't live there and it's not, their place of residence and it doesn't fall under the Mrs. Murphy exception we just talked about. Developments constructed for first occupancy after March 13th, 1991 are going to be covered by the Fair Housing Act. All units in elevator buildings are covered by the Fair Housing Act. And then ground floor units only in non-elevator buildings that are not otherwise covered. Okay, slide 22, please. Thank you. So the Fair Housing Act has some specific accessibility rules around adaptable features. For example, having reinforced walls in bathrooms for the installation of grab bars, lowered controls within reach for wheelchair users, usable kitchens and bathrooms so that there's sufficient room for maneuvering for a wheelchair user, or so that the kitchen, for example, or the bathroom could be modified to be more accessible for a wheelchair user. Accessible routes throughout the building. So from the front door to the door of your unit, that route needs to be accessible for someone with a disability. And common areas. This is kind of common sense, right? We need to make sure that people with disabilities can access all of the benefits of their housing. So the laundry room, a management office, lobby bathrooms. There must be at least one accessible entrance for buildings that are covered by the accessibility rules under the Fair Housing Act that we just discussed in the last slide. And when you take a look, if you take a look at the slides later on, it looks like we might have a link to the Fair Housing Act design manual that you could click on. Let's move on to slide 23, please. So Section 504 of the Rehabilitation Act was the very first United States civil law protecting people with disabilities. And Section 504 states that no qualified individual with a disability shall be excluded from or denied the benefits of or be subjected to discrimination under any program or activity that receives federal financial assistance. Section 504 requires reasonable accommodations, baseline program accessibility, reasonable modifications, and then effective communication for people who might have hearing or vision impairments and or other access needs related to communication being in a particular format so that it's accessible for them. It also requires certain accessibility rules for new construction and alterations. This is another civil rights law that we work with regularly in our practice that may be relevant to you in your self-advocacy and or advocacy for people with disabilities in their housing. Can we move on to slide 24? Thank you. So types of properties that are covered, again, it's properties that receive federal funding. So that's federally funded and subsidized housing, public housing, project-based Section 8, project-based rental assistance and RAD, rental assistance demonstration converted projects, properties that are funded through home, USDA and RDA, and then Section 202, supportive housing for the elderly. These are just some examples. It is not a fully exhaustive list. It is worth noting that tenant-based Section 8 or housing choice vouchers that are portable, so a tenant-based housing choice voucher, and certain older low-income housing tax credits, LIHTC, or state-funded subsidies will not be covered by Section 504 unless there is also other federal funding attached to the property. So for example, in the state of Maryland, any properties funded through LIHTC, the low-income housing tax credits, are covered starting in 2018. So newer programs, but older properties prior to 2018 would not be considered covered under 504. And we'll talk later on about how to identify if a building would be covered under 504. How to identify if there are federal subsidies attached to a particular property. Okay, let's move on to slide 25. Great. So some accessibility requirements for section 504. This relates to the construction of the property. New construction or substantial alterations to buildings require that at least 5% of the units of the building be considered accessible for people using wheelchairs. They have to meet what's called the UFAS, Uniform Federal Accessibility Standards, which requires that a unit have lowered countertops, sufficient turning space in the kitchens and bathrooms, like we talked about before, that everything be within the reach range, all the necessary controls to use and enjoy your housing, be within the reach range for a person who's seated in a wheelchair. They will also require, these properties are also required to have at least 2% of their units that are considered hearing or vision accessible. So modifications to lighting and emergency strobe systems and alarm systems. There must be a dispersal of the accessible units throughout the building. Can't put all of the accessible units in one place. That would be segregation, right? Other modifications must be made on request of the individual with the disability. So if someone specifically requests something, a landlord and a building covered by 504 would be required to change door handles to levers, switch the refrigerator to be side by side with the freezer so that they're both accessible instead of on top of each other if someone can't reach the freezer. And then installing grab bars in a bathroom at no charge to the tenant, as another example. And non-housing facilities, like we just talked about with the Fair Housing Act's accessibility requirements, must also be accessible under 504. So that includes the other facilities besides someone's unit, right? The lobby, mailbox or mailroom, a laundry room that's on site. If there's daycare in the building, that needs to be accessible so that people with disabilities can get to it. Halls, elevators, entrances, management offices, accessible routes. And it's also worth noting that even if a development, do we have a question? Oh, okay. Even if a development predates the implementation of 504, so it was constructed before July 11th, 1988, they may still have to make modifications to common areas to allow equal use if they're not physically accessible and a person with a disability is requesting that. Okay, if there are no questions, let's move on to slide 26, I think.
Hey, Evie, there are a couple questions.
Oh, great. Okay.
Okay. So one of the questions had to do, it's going back, I think, to the Fair Housing Act, and someone had asked, what if there are fewer than 10 units? And I think that actually is 4 units, right? But in terms of, does the Fair Housing Act apply if there are fewer than 4 units in a building, or how does that all work?
Sorry, I was looking at the chat. So let me make sure I understand the question. If there are fewer than 4 units, how could you say it again?
Like, does the Fair Housing Act apply? Can they? Yeah. And then I don't think that person was talking about accessibility, but maybe we can talk about accessibility too.
So I want to make sure I understand the question. The Fair Housing Act may still apply depending on the either for units with fewer than 4 buildings. That was the question.
Or 4, yeah, fewer than 4 in a building. Well, the person had actually said 10, but I think
right. So it might not apply based on the construction of the property, but either the Fair Housing Act or other civil rights laws that protect the rights of people with disabilities could apply based on other facts in this scenario, right? Is there a subsidy? Is federal funding attached? Even where the Fair Housing Act doesn't apply, you can still make a reasonable accommodation request of the landlord. They may not be obligated to grant an accommodation request or modification request, but they might still work with you. So I think that's, sorry, lots of questions are coming through in the chat.
Right. And I think, for example, if someone has a housing choice voucher, a tenant-based voucher, that is usually very, very valuable because the landlord has a guaranteed source of income every month, and they probably don't want to lose that. So your request for modifications or an accommodation should be taken seriously. There may not be the same requirement under the Fair Housing Act that they comply. There may be some state law protections that might be available to you as well, and that would vary according to the state. I think there was a question about modifications in Section 4. Do they apply to college dorms?
So if the property being the college, right, if they're receiving state funding, then we'll talk about the ADA right now, that applies. If they're receiving federal funding, then Section 504 applies. And the Fair Housing Act could apply. Again, it's sort of a factual question around, I got a question recently about could a fraternity or sorority, would that be covered by the Fair Housing Act? Or could they discriminate against who lives at the property? What's their obligation under the Fair Housing Act? And that to me starts to look like the second exemption that we talked about, where, is it a club, a membership group that limits occupancy to specific members? So I think often yes, but it might depend on the facts of the situation.
Yeah. And in Maryland, we have a very good decision on college dorms that's within the Fourth Circuit. So if you're in a state that's within the Fourth Circuit, almost certainly it would apply. Evie, there's a question about if I don't use a wheelchair, but I do use a wheeled mobility device, scooter, etc.
Right.
Putting that in there. Is there the same requirement for accessibility enforceable for me too, or is the act limited solely to wheelchairs?
Great question. And I should have mentioned this when I talked about the UFAS standards. So the Uniform Federal Accessibility or UFAS standards are designed based on what a wheelchair user would need to make a unit accessible for them. You do not have to be a wheelchair user to benefit from those accommodations and modifications, right? The concept of universal design being like when we make things accessible for people with disabilities, often it's accessible for more people, even if they don't have that particular disability. You do not need to be a wheelchair user to get into a UFAS unit, for example. If you have a mobility aid or a disability that similarly would require some of those features in your unit for the unit to be accessible for you, then you should be entitled to access that kind of a unit as well. And yeah, accessibility standards would be enforceable for you so long as you, the person with the disability, has a disability-related need.
Great. There is a question about substance use disorder under the Fair Housing Act. We're going to put that off because it's going to come up in a couple slides. Evie, you want to answer the question about Section 8 voucher discrimination?
I think we actually talk about that in a moment. I think it's coming up in a few slides. So what if we hold off on that for now?
All right. And then there's, I think, just one more question. Is there any reason why all new construction and renovation projects are not required by law to be planned in a manner to meet accessibility, visibility, and universal design principles, particularly if they're receiving federal or local tax benefits to support construction? It's a great question.
I mean, I think ableism might be the answer, but often new construction will be required to meet some baseline of accessibility because of the intersecting laws that we're talking about now, and whatever might be required at a local or jurisdictional level. Yeah, that's my short answer. Do you have a better answer?
In Baltimore City, we do have a visitability ordinance. It's a local ordinance, and it's interesting how that intersects with the Fair Housing Act, because there are some units that are visitable meaning that, you know, you can enter and leave the unit, use a first floor bathroom, for example, if you have a mobility disability, but that is not overall, you know, that's not entire Maryland law, and that's not the law in most states. I think that's an incredible idea, and something that if you believe that should be like that, share that with your federal and state policymakers and legislators, because that's the way these things get changed, you know, even when they're receiving, you know, of course, when they're receiving federal benefits like federal financial participation, they're covered by Section 504. It's not going to require every unit to be visitable, but a certain percentage. And the same with the Fair Housing Act. Every unit would be required to have that moderate level of accessibility if it was an elevator building, and if not, it'd be every unit on the first floor of a building.
I will say before we move on, if you have a question and you want to put it into the Q&A question and answer section at the bottom of the screen, that is easier for me, at least right now, than keeping up with the chat. So we might be able to answer your question more quickly that way. So Lou, do you want to talk about the ADA?
I absolutely do. Can we go? Yeah, we're here at 26. So the Americans with Disabilities Act covers, is not intended specifically in most cases to apply to housing. However, there are 3 titles to the ADA. The first covers employment. The second covers all activities of state and local governments, regardless of the size of the entity or whether a recipient receives federal funds. And what it does is extend the requirements of Section 504 to those entities. So here in Maryland, some of our local jurisdictions like College Park or Rockville have local public housing or subsidized housing programs. And even if they do not receive federal funds, which some of them do not, Section 504 would apply to them. The ADA also requires entities to ensure access to programs and services. So that includes public housing authorities, housing offices, for example. So by programmatic access, what I mean is they have to make accommodations and organize their programs and services so that people with disabilities can access them. So that may mean making communication available in a format that meets your needs in Braille and ASL, or to sending communication to someone else in addition to you, to ensure that that information will be acted upon. The ADA also requires people with disabilities to have equal opportunity to participate and receive the equal benefits of government goods, services, and programs, which means that housing providers can't have rules and policies that disproportionately impact on people with disabilities. So if, for example, the housing application does not offer the ability for an applicant to note that they need wheelchair accessibility, just as an example, and that person is losing out on units as they come up for offer because of that, that may be a form of discrimination that the housing authority or housing provider needs to remedy in order to make sure the person has equal access. State and local governments are required to follow architectural standards with new construction and alteration of buildings and facilities. With regard to the ADA, that often has to do with common areas, such as, you know, the leasing offices, if there's a party room or a computer room or a game room in the building, has to do with sidewalks and parking and other areas, although some of the other standards also address some of these as well. Under the ADA, housing providers must, and PHAs, meaning public housing authorities, must provide reasonable accommodations and effective communication. And importantly, Title II of the ADA requires that housing owned or operated by a state, county, or local government must make and pay for reasonable modifications, meaning physical changes to the housing, both new and existing facilities. Okay, go on to 27, please. Thank you. All right, so I mentioned this in the previous slide, but the ADA doesn't explicitly cover private housing, it doesn't really even cover housing expressly at all. But because of the breadth of Title II and III, it does cover public entities and PHAs, public housing authorities. It also covers areas in a development that are open to the public. So that would mean leasing offices, or if a housing development has a swimming pool that other people in a neighborhood could purchase a membership to for the summer, that swimming pool would be subject to the requirements of the ADA. The ADA covers services to obtain housing, for example, administrative offices. It also would apply to the application process. It would apply to inspections that might be required of a tenant, recertifications that might be required periodically to maintain housing. And as you'll see with many of these statutes, Congress, in passing the ADA, explicitly said accommodations are not required if they pose a fundamental alteration, and it actually says, and an undue financial or administrative burden. If we could go to the next slide. Okay, so I want to talk just a little bit about the Maryland Fair Housing Act. I realize not all of you are from Maryland, but just to give you a flavor for what Maryland does, because your state, most likely, I went through several of the states, although not all of them, has something similar. And I'm sure there are variations in every state, but the Maryland Fair Housing Act is substantially equivalent to the Fair Housing Act. It does explicitly add 4 additional protected classes of people that are protected from housing discrimination based on sexual orientation, marital status, gender identity, and source of income. The Maryland Fair Housing Act covers housing of not more than 5 units if an owner maintains the dwelling as a principal residence. Some jurisdictions in Maryland have local ordinances with additional protections, so that can also be a source of fair housing law. And complaints in Maryland can be made to the Maryland Commission on Civil Rights within 1 year. The HUD, I'm sorry, there's an error in there, to HUD within 1 year. I guess it's correct with regard to the Maryland Fair Housing Act. If you're going to make it on another basis like Section 504, it needs to be made within 6 months. And to local human rights commissions. Okay. If we can go to 28, 29, and I think Evie's good. Yeah, Evie would.
I thought we could just quickly answer the question since it's mentioned on that slide. If we could go back, thank you. Yeah, about Section 8 voucher discrimination, since I think we touch on it here. Under the Maryland Fair Housing Act, so our state law, source of income discrimination is illegal. And I did not get a chance to check what the law is in all of the states covered in this presentation, but it may be unlawful discrimination based on local state law or jurisdictional protections where you are too. So refusing to rent to a Section 8 voucher holder, at least in the state of Maryland, is considered a violation of that source of income discrimination.
I will say that if the individual meets all the the same criteria that any other renter needs to meet so a landlord can have certain requirements based on credit, based on criminal background, for example, or criminal convictions usually. But if the reason they're not renting to you is because you have a tenant-based voucher or any kind of voucher that doesn't always have to be a tenant-based voucher, but there are many different kinds of similar vouchers, then in Maryland, that is a violation of the Maryland Fair Housing Act. And I will say there is a case that is going before our Supreme Court in Maryland where a landlord has not explicitly refused to accept a voucher, but has created a barrier to the use of a voucher, namely saying you need to have this level of income in order to rent a unit here. And the people that are challenging it, the advocates that are challenging that are saying that amount should be the amount that is that I would have to pay with my voucher, not the entire amount of rent. So I think in that case, they were saying the individual could use their voucher, but they had to have three times, is it either 3 times the income
Yes.
of the rent every month. So if the rent's $500, they would have to have $1,500 a month in income in order to rent in that development, and that's being challenged, and our Court of Appeals has not heard the case yet, but it is pending. So we're eagerly awaiting the court's decision in that case because we do think that is source of income discrimination. Different states have different laws on this. Some states did a great job explicitly saying what constitutes source of income discrimination. I know DC has a source of income law, and I'm not sure about all the other states.
Oh, thank you. I just wanted to flag it since we were on the slide that talks about source of income. Great. I think we can move on to the next slide, 29. And now move on to slide 30. I'm going to discuss reasonable accommodations. So a reasonable accommodation is a change in a rule, policy, or practice or service that might be necessary to allow a person with a disability to have an equal opportunity to use and enjoy a dwelling unit or common space in their building. Reasonable accommodations can be necessary at all stages of housing, which includes the application process, during the tenancy, or during the end or termination of a tenancy, such as to prevent eviction, which is how I'm often using reasonable accommodations in my work. Okay, next slide, slide 31. So who is a person with a disability under the law? The Fair Housing Act and the ADA have essentially the same definition. Any person who has a physical or mental impairment that substantially limits one or more major life activities, or someone who has a record of having such an impairment, or someone who is regarded as having such an impairment. So it is important to note you don't need to receive Social Security or Social Security disability benefits to meet this definition. However, if someone is receiving Social Security disability insurance, that would be on the basis of them being determined disabled by the federal government. So they inevitably would meet that definition. And if the disability is not apparent or obvious, such as someone who uses a wheelchair or a scooter or a cane, someone who is blind or hearing impaired and uses visible devices, those are considered disabilities that are apparent and obvious, so that if someone sees you, they're aware that you have a disability. When a disability is invisible or is not considered apparent and obvious, you generally require a medical professional to provide some sort of letter or attestation that the person making this request meets the definition under the law. And we'll talk more about this in later slides, but those kinds of support letters can come from a doctor, a social worker, a therapist, or a case manager. I refer to it as almost anyone with alphabet soup after their name, so long as they have personal knowledge of working with that particular individual. And this answers, I think, one of the questions that we got through the Q&A earlier. The Fair Housing Act does exempt from the definition of a person with a disability, someone whose only disability is a substance use disorder or a current addiction to illegal drugs. However, in our practice, that's almost never the case. People have co-occurring or comorbid conditions. And often if someone has been diagnosed with a substance use disorder, maybe they're treating chronic pain or an unmanaged mental health condition. So there may be other avenues to pursue, if you're trying to make an accommodation request for that person. Okay, let's move on to the next slide. 30, what number is that? 2, thank you. So some of the legal requirements when making a reasonable accommodation request in housing, federal and state law prohibit housing discrimination against people with disabilities who meet that legal standard, which includes refusing to make reasonable accommodation requests. So making those changes, exceptions, or adjustments to rules, policies, practices, or services may be necessary for a landlord or a property manager to provide if it's required to afford a person with a disability equal opportunity to use and enjoy their dwelling. So some examples, which again, we'll talk more about this later on, but some examples of these kinds of policy changes might be changing the date when a tenant's rent is due, consistent with receipt of their Social Security benefits. In Baltimore City, there is already an ordinance that says that if you provide documentation to your landlord of the date that you get government issued benefits, they can't make your rent due before that date. But I know not every jurisdiction or state has a rule like that. So Baltimore City, you don't even need to make a reasonable accommodation request. It's already the law. But if you get paid your benefits on the 15th of the month and rent is due on the 5th of the month, you could, if you live somewhere that doesn't have a rule like that already, make a reasonable accommodation request that your landlord assess rent is due on the 15th, so that if there's a 5-day grace period, you're not late until the 20th. So that you're not getting charged late fees every month because your benefits come in mid-month instead of at the beginning of the month. Another example would be allowing an applicant to have an emotional support animal or a service animal in an apartment with a no pets policy, or granting transfer requests for reasons related to a disability without charging fees to move, break the lease. So that might be someone whose disability, for example, worsens. They can't take the stairs anymore. Or because of issues with noise, they need to be moved to a corner unit or a ground floor unit that's quieter for them. So we will talk more about this in future slides. But when making a reasonable accommodation request in housing, there has to be a connection or a nexus between what accommodation is being requested and the disability of the person making that request. Let's go on to slide 33. Great. So in general, the cost of a reasonable accommodation is not on the tenants. And part of that is because generally reasonable accommodations don't tend to cost anything. If you're changing a policy or a rule or how you're applying something, that should be free. Parking spaces, signs for parking spaces, restriping for parking spaces are all considered reasonable accommodations. And while those are things that would cost money, that's something the landlord has to pay for. So a tenant cannot be required to pay for an accommodation related to an accessible parking space. Generally, accommodations must be specifically requested by the person with the disability. You have to be a qualified person with a disability, meet that legal definition we just talked about, and you have to require the accommodation you're requesting because of your disability. When the accommodation must be necessary so that that person with the disability can be able to use and enjoy their housing in the same way as anyone else who does not have that particular disability. And under the law, housing providers are required to grant reasonable accommodation requests unless they can prove that to do so would be constituting an undue financial and administrative burden or a fundamental alteration of their housing program, which is a very high burden. And we will talk more about that in a moment. Let's move on to slide 34. So the definition of a reasonable modification is a physical alteration to the existing premises to afford a person with a disability full enjoyment of the premises. Next slide, 35. Some examples of reasonable modifications would be installing a ramp to allow access to a dwelling through an exterior door, installing grab bars in the bathroom where there might not be some already, levered door handles, specialized alarms for vision or hearing impaired persons, lowering a mailbox for a person using a wheelchair, lowered light switches or countertops. Let's move on to slide 36. So under the Fair Housing Act, often the tenant is responsible for making and paying for accessibility requirements or modifications when they are required by the tenant. However, if the development was already required to have been accessible under the Fair Housing Act, so they met those accessibility requirements that we talked about in the first section, or if there's DHCD, Department of Housing and Community Development, or federal funding, so any federally subsidized property, unfortunately not a tenant-based housing choice voucher, Section 8 voucher, or other tenant-based subsidies. Those kinds of properties under Section 504 are required to pay for reasonable modifications for that the tenant may be requesting. HUD has said that, however, a tenant may be responsible for restoring the apartment to its original state when they move out, but only if it would negatively impact the marketability of the unit to leave that modification up. And often, installing an accessibility feature would increase the value or marketability of an apartment. It wouldn't necessarily decrease it. So it depends on the particular modification. Let's move on to slide 37. So generally, restoration is not required when it's infeasible to do so. So if it's widening doorways for someone who uses a particular access device, installing grab bars in a bathroom, or installing an accessible route to a sidewalk, those are also examples of modifications that probably would not negatively impact the marketability of a unit. Tenants are permitted to make modifications to common areas. However, if the tenant is solely using that modification, it is a tenant's responsibility to maintain it. If a tenant is making a modification to a common area that's used and enjoyed by everyone in the building or multiple people in the building, the landlord is required to maintain that modification. Landlords can require approval of plans and a contractor, but they can't require a particular contractor, and they can't require a more expensive modification be made at the tenant's expense. Unfortunately, in our practice, this is where reasonable modifications can be, essentially denied, the landlord delaying the process, not approving a certain plan or a contractor and trying to make it more expensive for the tenant. So this is maybe where advocacy can come in to ensure that they are timely approving plans and not unreasonably denying requests to approve and ensure that modifications can get done.
So we have a bunch of questions.
I noticed.
So what if the modification that is requested by a tenant would mean that the unit no longer meets UFAS requirements or Fair Housing Act accessibility guidelines? For an example, a unit is designed with a compliant bathtub where this is very technical, but where a sink with a forward approach is located within the clearance, the tenant requests that the tub be replaced with a shower. A shower in that location would not comply because clearance would be obstructed by the sink, but would meet the needs of the current tenant.
That's a really good question. And I think we touch on this in a few slides. Again, it's really fact dependent, but to me, that sounds like an example. If it would be too expensive to make that kind of a modification, that might be an example of a situation where a landlord could meet the burden, saying that it's an undue financial and administrative burden. But it depends, I think. Would you have a different answer?
No, I think this is one where we've fought in Baltimore City and had a hard time with that. And I think the reason for that was really feeling that a UFAS accessible unit that is certified, in our case, it was the housing authority had to certify it pursuant to a lawsuit and keep it certified. And there was a concern where, a housing authority has 8,000 or 9,000 units, if this person moves out, how do we ensure that we remain in compliance? But I agree with Evie. I do think that if push came to shove, assuming it's not an undue financial burden, the landlord has to make the changes the person needs. So we see it often, things like a request for a screen door to have additional ventilation in a unit when typically UFAS doesn't. I think there are ways that there could be a screen door, but typically it is complicated and difficult to have a screen door in a regular door in a UFAS accessible unit, or having clothes bars in your closet lowered. Like if someone, for example, is in a chair and maybe they're not grabbing their clothes themselves anyway, they have someone assisting with that. They may prefer to have the higher bar so that their dresses aren't on the floor. And can the clothes bar be raised up as an accommodation? That would obviously not be a financial burden at all. So I think in that case, they'd have to do it. Here's another question. This is actually a Title I question, I think, but how many employee-only modifications need to be accessible, such as employee-only washrooms or lunch areas? Would they still need to have operable reach ranges as a normal mobility unit? This may be beyond what is required, what the intent of this lawsuit, but if there is an employee working in a housing development and they have a disability, how does that apply?
I'll defer to you on this one.
Well, I think Title I of the ADA would require reasonable accommodations. Certainly the Fair Housing Accessibility Guidelines, they don't only apply, and they apply to residential units and common areas. So if it's employee only, I guess you'd have to look at ADAG, the Americans with Disabilities Accessibility Guidelines would apply, and it would depend on when the common area, when the employee area was built, whether that has to be done. But if it's readily achievable and the employee needs it as a reasonable accommodation, the employer would need to make that accommodation, assuming it's not an undue financial and administrative burden. Okay, this is one that we deal with quite a lot. Any suggestions when doctors refuse to provide documentation of a reasonable accommodation need, and the person doesn't have other professionals who could provide it?
I mean, I think this is often where we come in, right? I work with tenants and who are using reasonable accommodations or reasonable modification requests to ensure that they can remain in their housing or to prevent eviction. And I will often call doctors' offices to try to explain to them what's going on. So having an advocate or a third party, if there's someone in your life that can support you, or if you're the advocate or third party, you should not need a lawyer to talk to your doctor to get them to write a support letter. But yeah, I think having strong advocates in your corner can be helpful. Putting things into writing, a skill that I was taught is, anytime a doctor refuses to do something, asking them to document the denial on your chart might make them reconsider the denial. Yeah,
it's a balancing act, because you may really like your doctor or need your doctor for other reasons, right? But I think trying to understand why is the place to start. So for me, it's really problematic, and I have seen situations where the practice or the corporation that owns the doctor's practice says our blanket policy is we do not provide reasonable accommodation documentation. To me, that's problematic and potentially actionable. Understanding that a doctor could in their professional judgment say, I don't feel like I understand this situation or your needs well enough to say you need an emotional support animal. So maybe you're going to your doctor for something that the doctor feels like maybe the therapist would be in a better position, and I just don't feel comfortable doing that. And in that case, I'm not sure there's much that really can be done except talking to the doctor about your needs and trying to get them to agree. That's hard. I'm going to skip the next two questions because they have to do with emotional support animals and emotional assistance animals, and we're going to talk about that in a little bit. How about a request in a senior facility for access to a ground floor, a transfer to the ground floor? Oh, for access to a community room restroom because the tenant can't wait until they get up to their unit. And I'm assuming this has to do with using the restroom because of urgency. So would that be a reasonable accommodation request, a good reasonable accommodation request?
I think it could be. Your building may also be required to have an accessible lobby bathroom already. If it's a senior building, it probably receives federal funding. So yes, and that may not be something that you have to make an individualized request for.
And I think maybe in that question, and Evie, they were talking about like maybe the community room is locked, but they're asking for it to be unlocked.
Oh, I
Something
see.
like that.
Yeah, I think that's right. Yes, in that case, you could absolutely make a reasonable accommodation request. But hopefully you should not have to.
All right, can a landlord charge for parking if ADA accessible parking is the only parking that has been required by a local government entity? So if the only parking is the accessible parking, can the landlord charge for that?
No, a landlord cannot charge for accessible parking. Specifically.
I
Yeah,
think
no,
this is a complicated question because
it is.
sometimes parking lots and parking areas are separately deeded and controlled.
Mhm.
It is an interesting question, and I don't know that this is a settled area of the law.
Yeah, I want to say, it's one thing if a landlord, the way I'm reading the question, the landlord's only charging for accessible parking because that's the only parking that exists, which to me feels like a higher burden is being placed on the maybe disabled residents. But, in a situation where everyone pays for parking, that might look a little different. So yeah, I think it depends. Lawyer answer.
In situations where a housing development assigns two parking spaces to a tenant, but the spaces are not located adjacent to one another, the tenant may be required to walk a distance to access the second space, which causes them additional pain to get to the second spot. Are landlords required to provide a reasonable accommodation for both parking spaces or only one?
I think it will depend on the facts of the situation. I'm curious why there are two parking spaces and if the person, with the additional pain is actually using both spaces or if they can just use the one space. Yeah, they might be required to grant a reasonable accommodation. But
Under some circumstances, yeah, I agree with you. Yeah. Is asking to be moved to a first floor unit because there are no elevators and the third floor unit the tenant moved into isn't accessible for them a reasonable accommodation?
yes,
Or
it can be.
and what advice might you have for a situation where the request for this was denied?
If it was denied in writing, that's great. We love a paper trail. It would be unlawful for the landlord to deny you flat out. We provided some, I believe, example of reasonable accommodation letters as resources for the presentation today. And so depending on, whether this request was made orally or in writing or in what format, in our practice, we would follow up with a letter explaining what is required under the law. So you could either try that or maybe find an attorney in your area to help you.
And I think this gets into what we're going to talk about in the next section is really having strong accommodation letters where there is a nexus, a clear connection between what you are requesting and your need, the need due to your disability. All right, this is another Title I question. If there's staff only parking, can a tenant request an accommodation? Oh, maybe it's not. If there's staff only parking, meaning no parking for tenants, can a tenant request an accommodation to be allowed to park in the staff lot?
I think so. I've had at least one client where that accommodation was granted because there was no other accessible parking for them.
Yeah. Have we heard of anything or know anything about, I guess this would be changes in the law regarding a PHA or subsidized housing program requiring individuals to work at least 40 hours to keep receiving housing services despite having a documented disability?
I am not aware of any changes in the law that would make that okay. And I think maybe there's a particular program you're thinking of or referring to. Having looked at different policies from different PHAs, generally there is an exception stated unless this person receives Social Security benefits or disability benefits. So I would look at the Housing Authority's plan to see if that exception is listed, and if not, you could refer to the federal regulations that govern whatever particular program it is, because there should be documented disability exceptions in the regulations, probably.
Okay, can we go to slide 38, please? All right, so I wanted to talk about paying for modifications because, as Evie's told you, under the Fair Housing Act, if there's no federal funding, most of the time it is the tenant's responsibility to make and pay for modifications. And how does that happen? And my apologies, this is going to be Maryland specific. However, I think we just want to encourage you to look in your state and encourage, you can call your P&A, you can call your Center for Independent Living or your CILS for more information on this. But I'll talk about in Maryland what we typically do to try to advocate for our clients to get modifications paid for if it's not already covered. So first of all, the first thing I'll say, and this isn't even on here, is we'll have a conversation with the landlord, because many landlords really want to keep their tenants if they're good tenants. And I will say, a lot of times, if a person has a physical disability and the unit meets most of their needs, they're probably not going anywhere. Why? Because it's so hard to find an accessible unit. So if there's something that you need that is not going to be outrageously expensive, a lot of times a landlord will do it, even if they are not strictly required to, because they want to keep you and because you're a good source of money for them. Many times, particularly if a landlord has a Section 8 voucher, is accepting a Section 8 voucher and can guarantee that funding, it's a good business decision for them to do it. So that's the first thing. The second thing is to look at Medicaid waivers. In Maryland, we have a number of Medicaid waivers for people with physical needs or healthcare needs, and they provide transition funds, for example, moving out of your own home into a rental unit, or out of a nursing home, out of an institution into a rental unit, and taking your Medicaid funding with you. There will be funding associated with that can be accessed typically every 5 years to pay for modifications. And there's usually limits on the amount of that money. So it's not necessarily going to pay for everything you need, but it may pay for a ramp, or pulling out countertops and lowering your countertops, or pulling out a shower and putting in a tub, or doing a walk-in shower in some cases. In Maryland, there are several programs that are local, usually through housing commissions or housing authorities, although they are not always limited to people who are receiving a tenant-based voucher or some other local funding source that provide for it. So Baltimore County has a modification program for voucher holders pursuant to a voluntary compliance agreement. They also have another program for people who are lower income and need accommodations. Baltimore City has a similar program for voucher participants. There's also a program for seniors that's separate, that's available. There's something called the Community Development Block Grant, CDBG. It comes from HUD, and that money can be used to pay for modifications, and many jurisdictions have a set aside of that type of funding that will pay for modifications for people. Local charitable organizations often do it as well. We sometimes access Habitat for Humanity. There's a program in one of our counties. It's something like Christmas in April or something that does these type of work for people. DDA is the Developmental Disabilities Administration. They offer low intensity support services. I think it is a lottery, but it's sometimes not so difficult to get into. I know that in Maryland, that program is proposed to be eliminated, and I'm not sure if it was reinstated or not with the end of our legislature, but oftentimes programs for people like DDA will have that type of services for people. I think, for example, Maryland has something called an autism waiver, and some of that funding can be used for modifications too. DHCD is the Department of Housing and Community Development in Maryland. They have a single family home modification program that is available for homeowners, seniors, and then other people through 2 other different programs, people who are not seniors through 2 other programs. There are other programs that exist too that can pay for this. Personally, I had used for my mom, the USDA has a Rural Development Administration, which may be a good source of funding. If you live in a more rural area, I think you have to fall into one of their categories for certain, I don't remember if it was census tracts or counties that are more rural, and they offer 2 programs, one of which is a low-income loan, which you have to pay back over a period of time, but it's really a very, very low interest rate and a very low amount of money that you pay back each month. And another one that is, if you're low enough income, that will that you don't have to pay back. It turns out to be a grant. So there's modification programs. I just want to encourage you that these do exist and to look into them. And certainly your P&A and your local Center for Independent Living can be a source of information for you. Okay.
Next,
Do you want to...
slide 39. So under the Fair Housing Act, a landlord would have to demonstrate that to deny a reasonable accommodation request, they'd have to demonstrate that the request is considered an undue financial and administrative burden or a fundamental alteration. And this is determined on a case-by-case basis. It has to be an individualized determination. They can't just make a blanket statement. If this defense is met, the housing provider has to continue considering alternative accommodations that would meet the person's needs. We refer to it as an interactive process. So they have to engage in ongoing dialogue with that individual. So as an example here, a tenant who uses a wheelchair can't get to the dumpster to take their trash out. The tenant asks the maintenance for the building to come take their trash every single day. Some leases have requirements that you have to take your trash out every day. HUD has said that this might be an undue burden for a small property management company. There aren't a lot of people at the building, but it would be reasonable for them to do so twice a week and to supply an inside trash receptacle in that tenant's unit where they can store it in between trash pickup days. Okay, next slide, 40. Some examples of undue financial and administrative burdens that show where the landlord can meet that burden. It would be a request for modifications that might cost too much. So walk-in showers in a high-rise development that has concrete floors, like we talked about with that really interesting and thoughtful question earlier. It's complicated. In existing federally subsidized housing units, a request for modifications to create a new UFAS unit could be considered an undue financial and administrative burden if the development already has the required 5% fully accessible units. A request for programmatic changes that are outside of the main business of housing, such as when a tenant might request that someone from property management staff walk or care for a service animal. Instead, HUD will consider requests for residual receipts to pay for alterations under 504. So if the property is owned by a housing provider, it's not covered by 504. then under the Fair Housing Act, a tenant would still have the right to make alterations at their own expense. Great, yeah, next slide, slide 41. So to determine if a development is federally subsidized, I love the National Housing Preservation Database. It is one of my best friends. It's free to sign up. And this is just a database where you can type in a property address or your city or any, qualifying information about the name of the building and where it's located. And it tells you if there are any federal subsidies that attach to that property. So that is a great way to find out if the ADA in Section 504, for example, may or may not attach to the building. Other ways to find out if you're living in a federally subsidized tenancy or someone you're assisting may be living in a federally subsidized tenancy would be if the tenant is required to recertify their income every year, if there are any lease addendums from HUD or references to HUD or references to the subsidy in the lease. It might be a HUD form lease, and there might be really small print at the top corner, left or right top corner, or at the end of the lease where they list the addenda. You can always ask the landlord or call HUD or the CDA. You can also, if you're in Maryland, we have a URL for the Maryland Land Records website, also free to sign up, a little less intuitive than the National Housing Preservation Database, but you can look up to see if there are any deed restrictions, which there would be for federally subsidized properties. This is important because it tells you which civil rights laws might apply to your building, in addition to the Fair Housing Act. Okay, next slide. So now we're going to think through accommodations and modifications that we just talked about. Next slide. This is slide 43. So as we've discussed, reasonable accommodations apply from the very beginning to the very end of a tenancy. That could be in the application process, in the resident selection plan. You can request assistance during the housing search process, during tenancy, at the point of lease or subsidy termination, and if it gets there, to eviction, including in court. Okay, next slide, 44. Some common barriers to accessing housing for people with disabilities that we see in our work would be getting and staying on waiting lists, missing documents, or being unable to obtain documents. A lot of my clients have difficulty remembering the password to their email and getting into their email, if they even use email in the first place. Maybe folks are unhoused and or have their mailing addresses changed for any number of reasons. Maybe they've just moved and forgot to update their address on a waiting list with the housing authority because it takes so many years to access housing. It can be difficult for people to go in person to the bank or to government agencies to get new documents if they've lost them, such as state ID, birth certificates, social security cards, bank statements, or other income information. It can be very difficult for people with disabilities to get good references, either because of ableism and discrimination. Maybe they've been living with their family and this is their first time moving out on their own because they haven't been able to find accessible housing. It can be difficult for people with mobility impairments to be able to go in person to search for housing or get to interviews for housing. Many of my clients have difficulty remembering deadlines or opening their mail. So they don't know about a deadline or that they've been selected for an interview because the mail's piling up. And they didn't know that they could request an accommodation that the housing authority email them in addition to sending them paper mail if email is what's accessible for them. Maybe they can't get to the mailbox because there's steps and it's difficult for them to get up and down the stairs, so they don't know that they got mail in the first place. Or they may be missing deadlines because of a lack of a stable mailing address. We'll also talk more in the next few slides about how credit issues and criminal background, criminal histories can also pose barriers to accessing housing. Let's move on to the next slide, slide 45. So in the application process, you can request reasonable accommodations, and here are some examples. For someone with a vision impairment, they might request that applications be provided in alternate formats. You can request, Braille as a format for applications. Someone who has a learning disability or developmental delay or just difficulty reading might need assistance completing an application through an applicant portal or on paper. They might need help reading and understanding documents. So it might be easier if someone read it to them and went through each step with them so that they answered the questions correctly and didn't get confused. It might be difficult for someone to get documents like we just talked about. So a request that could be made might be allowing an applicant additional time to submit the records after they submit the application, that they can update their application with the supporting documents later on when they get to them. And then if someone has challenges understanding communication or organizing responses, we would want to make sure that if it's a PHA, that they give that person what's called a supplemental and optional contact information for HUD-assisted housing applicants. It's a mouthful. It's a specific form that authorizes a third party to help out and be a point of contact with the housing authority, so that they can make sure that maybe a friend or a family member or support worker, whatever, is able to help you maintain communication so you're not losing out on housing. Okay, let's move on to the next slide, 46. Quickly, just recognizing we're close on time. So folks with disabilities often have poor credit, and you can request accommodations in the housing application process for landlords to waive credit requirements if there is a disability-related nexus. So maybe someone had disability-related medical bills or was out of work due to disability and that impacted their credit. If they were not able to pay attention to bills, organize repayments, maybe they fell out of treatment or their disability impacted their ability to keep up with the bills on their own. So we can again request that landlords waive credit requirements, maybe demonstrate that someone's got into treatment, is on a new medication, or that something has changed in their life. They have support from a third party. They're entering an automatic repayment plan or setting up automatic bill payments so that they won't forget about their rent in the future. Those are all examples of accommodations that you could request. And then changes in cognitive functioning. Again, you can waive credit requirements based on someone getting support so that they can meet the needs of the tenancy moving forward. Next slide, please. 47. So for folks who may have criminal histories, criminal records, it is not illegal in most places, so check your local jurisdiction. There may be a fair chance in housing law. I know DC has one. But for places, unfortunately, like Maryland, that currently do not, it's not unlawful for landlords to refuse applicants for housing based on criminal records if everyone is asked about that in the application process. For subsidized housing, they can only deny applicants based on their convictions. Private non-subsidized housing providers must evaluate whether criminal background policy have a disparate impact on any protected group. And they also have to demonstrate that their criminal background screening policy is necessary to achieve a substantial, legitimate, non-discriminatory interest. Denials based on arrest records and blanket bans on anyone with a criminal conviction doesn't meet that test. Let's go on to next slide, 48. So some examples, just very quickly, maybe someone's completed a drug treatment program. It's been a long time since the arrest or the conviction. Evidence from a healthcare professional that person's stable and now in treatment and they weren't before, or that they have personal supports to maintain positive behavior. Again, requests have to demonstrate a nexus between the disability and the past criminal activity. I think we can skip on to the next slide. Oh, there's just one thing. Sorry. Federal housing assistance can't be provided for folks, this is in federal regulations, who have been required to get on the lifetime sex offense registry or who have been convicted of production or sale of methamphetamine on federally assisted properties. Okay, next slide, 49. Often people with disabilities might require additional help as a way to fully use and enjoy their housing. And so you can request that you get an additional bedroom to accommodate a live-in caregiver, a live-in aide, or medical equipment. For a live-in caregiver, generally you need medical documentation showing why you need to have a live-in aide. The specific caregiver has to pass a background check. However, they are not considered a household member, so they don't benefit from any tenancy rights. Their income will not be included in household income, and their credit should be irrelevant. That should not be included in the background check. And generally, caregivers, live-in aides can be family members, except for a spouse in certain situations. and they're not required to be there all the time. They may have other support services during the day. Maybe they just need someone to check on them at night to stay over in case something happens in the middle of the night. It's going to be an individualized determination based on that particular tenant. And then to get additional bedroom for medical equipment, you will always need a support letter from a provider. If someone's writing you a prescription, for a hospital bed or a Hoyer lift, that's the best person to write that letter explaining why you need it. The equipment has to be large or numerous enough to require additional space for that storage. And the live-in aid may be required to store some equipment in their bedroom. Next slide, slide 50. So we did receive a couple questions in the chat about this. How to use as the ADA definition of service animal to distinguish from other types of assistance animals or emotional support animals. A service animal is going to be a dog that is individually trained to do work or perform tasks, at least one, for the benefit of an individual with a disability, including physical, sensory, psychiatric, intellectual, or other mental health disabilities, whereas assistance animals or emotional support animals are animals commonly kept in households that can be dogs, cats, small birds, rabbits, hamsters, gerbils, and other rodents, fish, turtles, or other small domesticated animals that are typically kept in the home. They can go anywhere a tenant can go on the property, including common areas. However, they do have to be under a tenant's control at all times. For dogs, it's reasonable for a landlord to require that they be leashed, for example. Housing providers can impose reasonable requirements for health and safety, like vaccinations for your pets, requiring that they be leased, requiring proper waste disposal. However, pet deposits and additional fees or pet insurance cannot be required for assistance animals. And you cannot require an ESA to be registered unless that's a local jurisdictional requirement for, I think, all animals of that type. Like in Baltimore City, you have to have proof of vaccination. It's a health and safety rule. So that's not something your landlord would be enforcing anyway. And then expenses related to upkeep for that animal can be considered a medical deduction from income for subsidized tenants that decreases the tenant portion of rents. And housing providers are required to accommodate non-resident visitors who have service animals who are coming to visit folks at the property. Next slide, slide 51. Here are some questions a housing provider can ask about assistance animals. Do you want to go through this or just move forward to the next slide, Lou?
Yeah, I think so.
Okay.
There was a question about a miniature
Okay.
horse.
Perfect. So housing providers can ask if the person with the assistance animal has a disability. If it's a dog, they can ask what task are they trained to perform.
I'm sorry, Evie, I was saying that we can probably skip this.
Perfect. Yeah. Let's go ahead then. You'll have the slides to look at it later. Okay. Slide 52. So many people with disabilities receive in-home supportive services. People may have rotating caregivers or frequent visitors to their units or need accommodations to the overnight visitor policy, or policies requiring tenants come down to greet their visitor in the lobby and bring them up if that's not accessible for them. Staff who assist with community support services may not be in scrubs or uniforms, maybe in street clothes. So making assumptions about an individual's circumstances or activities based on stereotypes can be considered unlawful discrimination based on disability or other protected classes. And we see this often in our eviction prevention work, where someone gets a notice of lease termination saying you have had unauthorized guests or people staying over for more than 14 days. And if they are coming to provide disability-related services, that is a defense to eviction and can be a reasonable accommodation request. Okay, moving on to slide 53. Landlords can end a lease if tenants have breached their duties under the lease. That can look like a failure to pay rent case, failure to maintain utilities, having unauthorized occupants like we just talked about, health and safety damage such as criminal activity, hoarding or unsanitary conditions, or threatening behavior. And as an accommodation, you can request additional time to pay rent if non-payment is related to disability, such as retroactive recertification or repayment plan, additional time to clean up and remove excess stuff if there's a hoarding or unsanitary conditions issue. You can demonstrate participation in treatment to address threatening behavior or problematic behavior that is considered a violation of the lease. Allow someone to stay with the tenant due to a temporary health reason related to disability and change policies related to overnight guests. allow a transfer to a ground floor unit if neighbors below maybe are complaining about excessive noise. Next slide, 54. I take a lot of cases. Oops. I think we went forward a couple slides. Do we want to go back to 54 or are we at time?
Yeah, unfortunately, we are at time. So I know we didn't cover the last few slides, and there's so much good information and so many great questions. I really appreciate it, Evie and Luciene, but we just don't have enough time. But I would encourage you, the presentation slides have been shared with everyone. They are also on our website, which I have posted in the chat. If you would like to reach out, Evie and Luciene, I believe you provided your contact information. And again, I think they also mentioned about the P&A system. So please make sure you research and you find your P&A. If you're not in the state of Maryland, they're in every state, and they're a fantastic resource of information, as you can see from today's presentation. So thank you again, both of you guys. This has been fantastic. There has been so many questions and some great engagement by our audience today. Obviously, this is a hot topic and one that many people have questions about, and we appreciate your time. Appreciate you providing all this information and all the resources. Again, visit the ADA's website because we have all of their resources and this presentation posted. So I'd encourage you to check all that great information out. And we will be having another webinar next month in May. So make sure you stay tuned and you check that one out as well. It's on accommodating mental health conditions. So I encourage our audience to check it out and register. So thank you again. And thank you again for our presenters. I greatly appreciate your time and everyone for joining us today. Thank you.